A brief note on National Medical Commission Office Memorandum fixing 50% of seats in private and deemed universities on par with the fees of the respective state governments and union territories. Hello medical students, welcome to my YouTube channel. In this video, I have presented the National Medical Commission Office Memorandum that stipulates the fixation of fees for the 50% of seats available in private and deemed to be universities on par with the fees charged by the particular state government and union territories. According to NMC Clause 10(1)(I) of the IMC Act 2019, the National Medical Commission shall frame guidelines to determine the fees and other fees to all private medical colleges as per the NMC Act. The Office Memorandum further states that the benefit would be first made available to the students who are all accommodated in government quota seats, but restricted only to 50% of the sanctioned strength of the private medical colleges. Further, it states that if the total number of government quota seats are lesser than the total sanctioned strength of the private medical colleges, the rest will be benefited purely on merit basis. This is what National Medical Commission Office Memorandum says in February 2022. The private medical colleges on their part argued that it is not possible to provide medical education with such subsidized rate because they have incurred higher expenditure for establishment of medical colleges in terms of building, infrastructure facilities, teaching and non-teaching staff salary component, lab facilities, etc. It is possible for the government to afford medical education because the cost of the education is taken over by the state. But it is not optional for these private and medical and deemed university colleges. However, the NMC insists to implement this new decision from the academic year 22-23. Upset over the move by the NMC, the Private Medical College Association in various states filed writ petition before their concerned state high courts. First, the Private Medical College Association has filed the writ petition before the High Court of Kerala. The Kerala High Court pronounced its judgment, said that in Kerala there is no longer seats like government quota as management quota seats, and all seats are filled up by the Commissioner of Entrance Examinations since 2017, purely on merit basis through a transparent counseling process. This may be applicable to the states where there are government quota seats and management quota seats exist. But in the state of Kerala, there was no such quotas and hence it is not applicable in the state of Kerala. Then next, coming to the Madras High Court, the association filed writ petition challenging two provisions. One is the NMC Clause 10(1)(I) of the Act, which empowers the Commission to fix fees, and another is it is not practicable for offering seats with such a subsidized rate to 50% of their seats in private and deemed to be institutions. The bench, after hearing the arguments on both sides, upheld the validity of the NMC Class 10.1, that is, NMC has powers to fix fees and other charges. But coming to the another part regarding the implementation of allowing 50% of seats on par with the government rate, the Madras High Court observed that it is not permissible to provide two sets of fee fixation, one for the first 50% of students with a meager amount and the next 50% of students with exorbitant fees. In such a scenario, cross subsidization will occur. That is, the second part of the students subsidize the cost of the first part of the students. In this scenario also, there are possibilities of students not taking the seats because of the exorbitant fees, and thereby the seats would go vacant, which is a waste to the institution as well as to the nation. In the meantime, the less meritorious students can take such seats, and where the merit is also sacrificing. Therefore, it directs the National Medical Commission to frame a new guidelines and come up with a fresh proposal taking into consideration of the observations of the High Court. Till such a time, the existing fees will prevail. This is the operative portion of the judgment by the Madras High Court. Then coming to Madhya Pradesh, when the government advocate is asked about the government quota seats in private medical colleges, the advocate replied that there is no government quota seats in private medical colleges as far as the Madhya Pradesh state is concerned. So all the three high courts are not favoring the memorandum which require modification based on its observation. In the meantime, the Association of Health Institutes in India approached the Supreme Court of India with these judgments. The Supreme Court took note of this plea and fixed the date of hearing. This case is listed on 21st October this month. This is the present status. In the meantime, the PG counseling has already started and the undergraduate counseling is going to be started. The students are paying the amount without reference to the NMC Office Memorandum because of this litigation. Then we will look into the documents for this. See, this is the NMC Office Memorandum issued on 3rd February 2022. As per Section 10(1)(I) of the NMC Act 2019, the Commission shall frame guidelines for determination of fees and all other charges in respect of 50% of seats in private medical institutions and deemed to be universities which are governed under the provisions of this Act. This memorandum is challenged before the High Court of Madras. In Kerala, there was no government as well as management quota seats. Every student in all private medical colleges and deemed universities is allotted only by the Commissioner of Entrance Examination through a common entrance test and a counseling program. Therefore, this office memorandum is not applicable to the state of Kerala. This is Madras High Court. The judgment was released on 9/9/2022. I have provided the links in the description box. This judgment contains 74 pages. The aforesaid may have a serious consequence because the poor may subsidize the fee of the rich, as fee structure for 50% of the seats would be at par with the fee in the government medical colleges, and obviously those seats would be taken by the students who secured merit position. The apex court analyzed the aforesaid by giving illustration that a rich candidate would be in a position to take coaching and may secure higher merit position, and based on the aforesaid, if he occupies government seat, then he would be paying a meager amount, while the rest of the 50% of seats would be filled by the remaining candidates, and they would be paying higher amount of fee to subsidize the fee of the first 50% students, and in that even the poor may subsidize the fee of the rich. This aspect could not be taken into consideration by the expert committee while making recommendations, though it has referred the judgments of the apex court on the issue. Finally, in the result, the writ petitions are disposed of with the direction that in the light of the observations and finding recorded in the proceedings paragraphs, the NMC should at the earliest come out with a fresh office memorandum after giving a re-look to the office memorandum under challenge. Till the exercise aforesaid is undertaken, the fee structure may be governed by the present system. This is the final findings of the Madras High Court judgment. Then coming to Madhya Pradesh, on a specific question being asked, the learned government advocates submit that there are no government quota seats in the private medical colleges in the state of Madhya Pradesh. In view of the submission made prima facie, we are of the view that the impugnant office memorandum may not be applicable so far as the petitioner is concerned. Hence, to the extent the office memorandum and all consequences shall remain stayed. Medical education, Supreme Court to hear plea challenging NMC direction for government fee to 50% private colleges on October 21. The Supreme Court decided to hear the pleas challenging the validity of the National Medical Commission's decision, stipulating that the fee of 50% seats in private medical colleges and deemed universities should be at par with the fee in the government medical colleges in that state and union territory on 21st October 2022. This is the present status of this case, and we will see and wait how arguments are going on both sides and final findings by the Supreme Court of India for implementation. The next hearing is on 21/10/2022. Thanks for updating. Thanks for watching. Please subscribe to my YouTube channel.